So beginning with the format of a competition, in a mediation competition room, you will see two parties. One party is a requesting party, that is the people that invite the other party for a mediation. They suggest mediation. They say that nahi humko court nahi jana, humko itna wo sab nahi karna. So let's meet and discuss this. Let's resolve this amicably. So that is the requesting party because they request for the session, right? Then the other party is the responding party that responds to the request. They come and meet the other party. And then, of course, there is a mediator, that is the neutral third party. They are not biased. I'll tell you about the mediator in detail, but for now, there is a mediator. In some competitions, there are two mediators who are competing against each other in the same room, but that depends. So there can be one mediator or two mediators in the room. And then, of course, there are assessors, that is your judges who will be judging you on the basis of the marking criteria that has been given to them. So this is the setup of a room. Now, before you go for a competition, before you go for your round, you get a set of parties get a common set of points as your general information, which is the GI. Both the parties get the same set of information, and that is called the GI. So that's basically a common background to how the dispute, rather, how the situation arose, what happened, and what the positions of both the parties. Now, when I say position, we'll be talking a lot more about what position is, what an interest is, how they're different. And I want you to focus on this throughout the session because this is the essence of mediation. So while a general information tells you about the position of a party, an interest is something that you have to get the other party to tell you. So you are given a GI before the round, and right before the round begins, half an hour before or 45 minutes before, depends from competition to competition, you are given confidential information, which is different for both the parties. Party A, that is the requesting party, will get a different set of confidential information, and party B will get different confidential information. That is your some more background to what is happening on your side, right? And that is where you will most probably find your interests. Why, what is the reason behind your position? Why do you want a particular thing? And that why is your interest. All right. I hope everything's clear. It's pretty simple till now. Okay, good. Shikhar, can you share the picture of the diamond model?
Yeah.
Okay, so this diamond model is basically going to tell you about the order of events in a mediation competition so that you know what happens first, what happens after that, etc., and how the session comes to an end. Once we can see the model, I'll tell you about what we'll be discussing. I'll tell you about the individual steps in detail. This includes the opening statement of the mediator and the opening statement of the parties one by one. The mediator naturally begins because wait, before I begin, I first want you to know what mediation is in simple words. So it's basically a discussion which is facilitated by a neutral third party. That's the mediator, of course, who helps you reach a mutually agreeable solution. That is, in simple words, it's basically a discussion. That is what mediation is. All right. Now, with that in mind, with the whole, yeah.
Just adding on to what ma'am has said right now. So mediation is more or less like a storytelling thing because since consider a situation where you are having a dispute with your mother and in normal circumstances you won't go to a mediation chamber for this, but consider this, that two parties are having trouble and they want to resort it, so they'll reach out to a third party who will be enhancing that whole matter in such a way that each party goes with a win-win situation, like they have something in their hand. So mediation/negotiation means this only, that you have to leave something, like given something in return of, in lieu of something else. So you get something else also. That's whole this matter is all about. So as per that, GI, as I say, like in my words, GI is a general idea of this whole problem, which you get. That's the general information. Whereas CI comes, that comes half an hour prior to the competition. CI is called as a contouring of that idea. So CI will tell you that you can't lose, like it will give you a bracket. It will say that this is your upper limit and this is your lower limit. You can't go beyond that and you can't go below that. You have some demands, you have to look into this matter only. So CI's role is this much, and GI is, as I've said, that it all tells about your. It's like moot prop only, but you have so mooting and mediation. Supposedly, ADR and moot competitions are different in such a way that for mooting you'll have to prepare for the past 1 or 2 months, right? But in ADR you will have to practice throughout. But ADR is all about presence of mind and thinking on your feet. So you have to go with that flow. That in that competition, you have to think from that mindset that whatever the other party is throwing on you, you have to first of all maintain that humility and you have to take it in such a way that you're not losing out everything. So as I have gleaned from my own experiences, I have realized that mediation is not about being stern and asking various things from the other party and letting them end at a very on a very you know ugly note. No, that's not mediation is all about. Mediation is also something where you have to sternly ask the other party, but you'll also have to reasonably ask them. At the same time, if the other party is being too fluctual, like they are giving you everything, then again the essence of mediation gets spoiled there. So you have to maintain a very mid chord in that whole game. So it's all about the mind game throughout the competition. Yes, ma'am. You may carry on.
Yes. So with everything that he just said in mind, I'm sure you have a better idea of how mediation works. So as I was saying, the opening includes the opening statement of the mediator and the opening statement of the parties. I'll quickly tell you what the opening statement of the mediator is like, and then Shikhar can tell you more about the parties' opening statements. As a mediator, I would always advise that you, at the very beginning, set a friendly environment. I'll just stop. Have you guys noted down the order of events? Then it'll be easier for me to. I can just stop sharing the screen then.
Or you can just click a picture or screenshot of it.
Yeah, you can refer to it side by side.
So can we get a yes? Have you noted it down or not?
Yes, I'll take a screenshot and share it on the group.
All right, good.
Great. So I'll just stop sharing. Okay. Yeah. So as a mediator, I would always suggest that you begin and you begin with a friendly tone so that everybody is comfortable from the very beginning. For example, my beginning is very simple, but I want people to feel comfortable so that they're comfortable when they share their side of the story, right? So I'll just be like, hello everyone. I hope you're having a nice day. I'm Ashwarya, your mediator for today's session. So you smile in a way that is not creepy, but comforting. All right. That being said, the mediator is supposed to tell the parties a little about mediation as a process, what it is. So you just tell them that this is opposite to what happens in court. And instead of knowing that one person will win and the other person will lose, here you can reach a win-win situation. That is all you need to say about it, right? You can tell them that it's informal. You can tell them a couple of other things, but this is how you start. You tell them a little about mediation. Then you tell them about your role as a mediator. And this is where I want you to note down some points. So as a mediator, you are supposed to act like a facilitator. You help the conversation continue. You help the parties become more open with their interests. You help the parties understand each other's interests, right? I will be talking more about what interests are. I'm just using that word a lot, but we'll come to that immediately after we're done with the opening statements. So you help the parties understand each other's interests better. You have to tell them that you're not a judge or an arbitrator. So your verdict isn't final or binding. It only becomes binding after the agreement that you've reached becomes an official contract, right? Before that, nothing is set in stone. All right. So you tell them that you're not a judge or an arbitrator. You're a mediator, you're a facilitator. You tell them what the pillars of mediation are. There are 4 pillars. The first pillar is confidentiality, which is very important. You tell them about this. You tell them that unlike what happens in court, where the proceedings are public, here everything is within the 4 walls of the room. So it won't go out. It's confidential. It stays between the parties and with the mediator. And then I've seen mediators add this very common line that after the end of the session, I will just destroy these notes. You can add it if you want to, but it's become way too common. So just think of more creative options for the same. Then we've got the second pillar, that is neutrality. You are an unbiased third party. You can't ever show or you can't side with one party. So don't even don't refer to one party too much, because that will show that you're kind of bent towards what they are saying. So just keep your words, keep your statements very, very neutral. And what you are supposed to tell them is that you're a neutral third party, and if at any point they feel that you are biased, they can ask for a different mediator. This is what you're supposed to tell them. All right. Then the third pillar is party autonomy. Mediation is a party-driven process. So the parties are the ones that have to come to a conclusion. They are the ones that come up with ideas. They will agree to solutions. They will propose solutions. Options. The mediator, in very clear words, I'm telling you this, cannot offer advice. The mediator cannot say कि तुम 50% रख लो और तुम बाकी 50% रख लो. That is not allowed. You will be marked down for this. All right. The mediator cannot give advice. What the mediator can say is something like, how about sharing the profit? Or that's also advice actually. So you have to suggest things in a way that it doesn't seem like advice. Ask questions. Ask them if they are willing to share a portion of the profit or something like that, right? Then don't give advice overtly. Then you have you don't have to explain so much in the opening statement. The opening statement should be short and crisp. I'm just telling you so that your concepts are clear. And the last pillar is voluntariness. The process is voluntary, and the parties can quit whenever they want to. They can get up and leave. But of course, that's not the intention. The intention is to stay, discuss, understand, and leave with a win-win situation. Is that clear?
Ma'am, could you repeat the third pillar, please?
Party autonomy.
Right, ma'am. Thank you.
I hope everybody got that. Clear?
Yes, ma'am.
Yes, ma'am.
Yes,
Okay.
ma'am.
Great. So I'm done with the pillars, and now I have the role of the parties. In the beginning itself, when you begin as a mediator, when you begin with your opening statement, you will say that I'm your mediator for today's session, blah, blah, blah. And I will tell you about the process of mediation, then my role as a mediator, then your role as parties, and finally the format of the session, right? So I've already told you about the first 2 segments. Now the third one is the role of the parties that you're supposed to tell and explain. And the role of the parties is basically that they have to be calm, patient. They have to listen to the other party. They can't cut each other off. Everybody has to be given equal opportunity by the mediator. Everybody has to stick to the time, but make sure that you tell them that time is no bar, since you can always meet for subsequent sessions. All right. So tell them that today we have a limit. So let's try to be as fair as possible and stick to the time limit. But time is no bar in general, because we can always plan a subsequent session. All right. Then you can always add some creativity here, that you can add stuff like you're supposed to focus more on your interests rather than positions, and I will help you do that as your mediator and stuff. But this is just very common. So just be as creative as possible. You can come up with newer ideas to tell them that you promote amicable settlements, how you want the room to be very calm. You can add a couple of jokes here and there. So that is all up to you. Nothing is set in stone. As Shikhar said, it's all about being spontaneous and thinking on your feet. All right. So you see how you are able to set a comfortable environment there according to the behavior of your parties, because not everybody is the same. So it depends. Okay, the role of the parties. And then finally, you come to the format of the session, which in which you're just supposed to tell them the 3 steps very briefly. That after my opening statement, don't say that. Just say after me, I'll have the parties begin with their opening statements, where I would like you to briefly explain why you're here and what you would want to achieve by the end of this session. Now, the second part, what you would want to achieve by the end of the session, the mediator has to pay extra attention to while the parties are speaking, because this usually comes towards the end. But this is what will help the mediator set the agenda, which is the second step after the opening statements. So what will you say? You'll say, I would like the parties to explain briefly why they're here and what they would want to achieve by the end of the session in their opening statements, right? And then you tell them that this will help you set the agenda. After that, there is, of course, agenda setting, which is with the help of what the mediator has noted down and the permission of the parties. The order and all does not matter. It always depends on the parties, what they want to talk about first. There can be 5-6 issues. Agenda is basically something that has to be talked about, right? And it can include anything. Say the future of the contract, say the unpaid dues, say anything, whatever depends on the proposition, of course. But basically the things that have to be talked about or the issues that have to be discussed, right? This is something that the mediator has to gather from the opening statements of the clients and the counsels and form the agenda. All right.
Ma'am, I have a doubt.
Yes.
Ma'am, would the mediator be getting the confidential information of both the teams? No.
No. So even though the mediator has no information besides the general information, this is actually the fun part, because it is important that the mediator be neutral throughout, and this helps you be more neutral.
So, ma'am,
The fact that
basically so mediator is not given any information other than the
General
job that you get, and they're not allowed to make suggestions or advise them on how the parties are supposed to go about the competition or the settlement. So what is it that the mediator does? I mean, other than being friendly?
This is a very common question, but so a mediator is not supposed to offer advice overtly, as I said before, but the mediator has to ask the parties questions in a way that you indirectly offer advice plus help the parties understand their interests. See, you don't know. I'll just do a short one-line role play with Shikhar to make you understand what interests and positions are, and I think that is when you'll be able to understand better what the role of a mediator is, right? But in general, a mediator is supposed to ask important questions like why. The position of party A, what they want is a cycle, and party B wants the same cycle. The mediator is supposed to find out why party A wants that cycle, why they can't reach a settlement, what is the issue behind this, what is it that party A cannot divulge in front of party B. And here comes the caucus, which is the third step up, which is, no, I've not talked about a joint session yet, sorry.
Right. So the mediator, they try to find out the interests of the other party, right, by asking them questions of both the parties, basically.
By asking questions, by keeping them calm, by keeping them on track, by making sure that they're not stuck on the same issue.
Right. Because isn't this also what negotiators do, like of both the parties, and like do they not have to ask questions to the other party and
they can
deduct their interest?
They can, but the negotiators will always come with the mindset of getting what they've been asked to get in their confidential information. So they won't have the other side of the story. Your job is to make them understand the other side of the story and make them reach a compromise.
So first you have to know what the other side of the story is, and then you have to make it clear to the other to the other party, the one which is
not make it clear as such, but you're supposed to help them reach a place where they can agree on something which is mutually beneficial. Where
they have to bring out the interests of both the parties, and then they have to let them solve among themselves.
Yes.
Like, ye interest hai, abhi tum dekh lo. Something like that.
तुम देख लो नहीं, मैं तुम्हारी हेल्प करूंगी, मैं दिखाऊंगी तुमको.
Right, ma'am. Got it.
Right? So you'll understand better. After that example, you'll understand better.
Right, ma'am.
Yeah.
Also, if I may just pitch in for a minute.
Yeah.
So I think, Manat, when we say that the mediator has a role, so it is a very harsh truth as far as I have heard from people, that a mediator has to steal that thunder in the whole
Yeah.
session, because it's all a party driven process and more of a client driven process. So the parties are there and they might not you know welcome a third party to be indulging in their conversation. Still, the mediator has a very tough job, and I think Ashwara ma'am has delineated that whole process. But
They have
moving
to
on,
make themselves important and apparent in the process. Is that what you're trying to say?
kind of that
Right.
only, because sufficiently, if I may say, the parties, when they open their statement. So I'll just start with the opening statement of the parties. Okay, then Ashwara ma'am can take from where she has left. So the opening statement of the parties is going in this way, that they have to first of all give their speech, and it's their time to shine right now throughout the session. It's the only time when they can shine. So first one is the council. First one is the client, sorry, because it's a client-driven process. So client has to state his opening
But
statement.
remember, I'm sorry I'm cutting you off, but you have to keep in mind that even though this is your time to shine, you can't take more than 2-3 minutes, because the shorter your opening statement, the better it is for you, because long opening statements make everything boring and people will lose interest, the judges will lose interest. So it has to be very impactful, but it has to be short and crisp.
So as we say that the brevity is the sole art of lawyers, that has to be maintained. But at the same time, you have to diverge into the gravity of it. So because I really like this way, the way I try to explain my whole situation. So this is my way. Like, you can devise your own ways. In my opening statement as a negotiator, irrespective of me being a counsel or client, I try to first of all state my side of the story, how I have started from rags to riches, and then this all has happened, so that I can gain that emotional empathy from people. Then I come on to the issues which I have. So in this way, I have delineated my whole story, and then at the end, I have just stated, boss, these are my issues. Now let's try to resolve them. So now we have to also show that how accommodating we are. We have to ask the other side that what are your issues, and as per that, we'll see that we are having some conflating issues as well as some are diverse issues. We'll ask them very openly, do you want to discuss the conflating issues on which we are having common interest, or do you want to discuss those diverse issues in which we are having some loggerheads already? And as per that, with the cooperation of mediator, we'll ask that as per that, the agendas will get set. And in some cases also, like in I think ICC mediations, the mediator has to jot down those agendas on the whiteboard, and as per that they go. So before we discuss the interest position and issues, which is the main task of it, like we have to acknowledge these tasks, whatever our interest and position and issues are. Before moving on to these, I'll just state you that a council's opening statement goes in such a way that a council has to show that, although he is a client's counsel, but he has his own principles also. So he'll try to maintain those levels of propriety and other moral things. And as per that, he'll try to, see or look out that the whole procedure is going on a very smooth note. At the same time, he has to deal with the technical parts of the issues. So it can't be a case where the client is stating everything and the counsel is just a silent duck over there. It can't be a case. So it is a game of cooperation throughout. Like, a client and counsel has to go in such a way. As per that only, we'll try to Ashwara ma'am, you can just chip in right now.
Yeah, so just one more thing. Even though a lot of people have different opinions about this, about the role of what the client is and what the counsel's role is, it is important to understand that the role is equal. It's 50-50, and that is what we were clearly told by one of the judges in my last competition. And they told us to make sure of the fact that it doesn't look like one person is dominating the other, or that you're on different pages. You have to be on the same page. You have to complement each other's ideas, and you have to make sure that even though this is something that will happen there depending on what the situation is, but don't try to shine so much that you take away the other person's speaking time, or the other party's speaking time. Don't, if you take a very aggressive approach, it might backfire. So you have to analyze the situation, and I personally feel that it's always better if you are the more mature party. If you stay a little more quiet as compared to the other party, this does not mean that you're not in a good position. It just means that you're listening more, which is also something that is very important for getting better marks. Shikhar, yeah, Aditya, yeah.
Ma'am, so how many people are exactly there in the competition? Like there are two clients, and then each client has their own counsel, and then there is a mediator, which is us who are taking part. Or there might be two mediators as well.
No. So yeah, so there is one party, that is two people from one college. For example, the requesting party consisting of two people, the client and the counsel from one college. Then the responding party consisting of the client and the counsel from the second college. Then there is a mediator from the third college. If there are two mediators, then there's a fourth college. And then you have the judges or the assessors. So that is what a mediation room looks like.
Okay, ma'am. Thank you.
Yeah.
So it's more or less like a situation where two parties have come. As I said, they are having troubles, and each party has clients because they are the persons who are having this trouble, and they have called upon the councils, and they have reached upon to a third party, that is either two mediators or a single mediator. And as per that, we are sitting across the table and having a discussion. And most of the times the discussions are very peaceful, but yeah, at times they have gone wild. So we can move on right now to the interest, position, and issues. So,
No, wait, I have to complete the mediator's opening statement.
Right.
Yeah. So we'll just begin with the interest and position aspect. But to quickly summarize, the mediator introduces, the mediator begins with their introduction. Then we have the mediator telling the parties a little about mediation, then about the role of the mediator, then the role of the parties, and finally the format of the session. I was on the format of the session. After the opening statement of the mediator, you have the short, crisp opening statement of the parties, where you ask them to tell you what they want to achieve by the end of the session, through which you get the agenda, which is the second step, the setting of the agenda. Then you have the joint session, where you exchange ideas and more ideas and more ideas, where you generate options, where you try to understand the other party's interests. That is the main part where the discussion takes place. That's called the joint session. Then you have something called a caucus. CAUCUS. This is the part where one of the parties can request the mediator to have a private conversation with the mediator without the other party. The mediator can also ask for a caucus with one party, and the party can also ask for a caucus. So this is usually a 3 to 5 minute short session where the other party is asked to leave the room, and you can have a private discussion with the mediator. The point of this is that if you have something in your confidential information which is detrimental to your side and you don't want to divulge it to the other party, you can divulge it to the mediator during a caucus, because whatever happens in this caucus is confidential. So until you expressly allow the mediator to divulge this information to the other party when they come back, the mediator cannot do it. So this is a personal problem that you can share with the mediator. He can take note of it, and then he can have that mindset where at least he knows your interest, so he can push the other party towards addressing the same. And this is again where the mediator's role comes in. Is that clear? If everybody's
Yes, ma'am.
understood, great. So after the caucus, you again have a brief joint session, and itna, by this time itna bachta nahi hai session mein, since it's usually a 40-45 minute session. And it's not always compulsory to call for a caucus, depends on what competition you're going for. But if it's not compulsory, and if you feel like the session is going smoothly, don't just call for a caucus to get brownie points, because you won't. The judges always feel that it's better if you make good use of your time, and if you call for a caucus just to show to the judges that you're aware of what a caucus is, it will be bad for you because you will be marked down, right? After the caucus, you reach the part where you summarize whatever the mediator summarizes, the discussion that has taken place, the progress that you've made, and if by the end of the first session you have an agreement, then you talk about finalizing that agreement. Otherwise, of course, that usually doesn't happen, and you set a date for the next session, and the mediator is supposed to ask you towards the end of the session when you would want to meet again, and you can just in general say next week sounds good and something like that. So this is everything about the mediator's opening statement. As far as the opening statement of the negotiator, the negotiating parties goes, they are supposed to, it's usually the requesting party that begins, but again, this is not set in stone. So yeah, I think Shikhar has explained everything about the opening statement of the negotiators. So now we can begin with the interest position thing.
Just on an end note, I just want to say that, there are some housekeeping rules when we talk about the opening statement of each party, whether it may be mediators or negotiators. And if they are being kept intact, then your marks are also intact, because your marking is also based upon these opening statement and whatever you have stated or not. So if the counsel hasn't stated in his opening statement about the confidentiality of this whole matter, then it might be a case that his marks will get deducted. Whereas if the client has not stated the issues in a very nicest of the way, then it might be a case, or he hasn't divulged the confidential information's aspects. He has not to state that this is my confidential information and therefore mark my words. No. But he has to, in a very sly way, he has to state that information over there, that it might not get revealed also. It might just look as a very normal demand to the other party. And in that way, this is the whole smartness which you have to show. So I just want to say that if you have stated your opening statement in a nicest way, then for me, half of the game is won, because you have already established your ground over there. And you have already stated whatever you want from the other party. As per that, you want this session to go driven. But just make sure that you're not being too overwhelming on the other party, that that judges are getting to see that you're being that party who's being the one who is very aggressive, or just not letting to reach to a conclusion or concord. So it shouldn't be a situation. So before we move on to interest position and issues of the negotiating party, ma'am, do you want anything else to come up right now?
No, I think we should continue. We don't have a lot of time left, so
All right.
let's just, yeah. Okay, so quickly, this is an activity and I want everybody to pay attention. The difference between interest and position, this is something that we've been talking about since the very beginning of this session, and it's very important for the mediator, for the negotiators, for everybody. What you want, that initial demand of yours, is your position. I want 100 kg oranges. The last batch in the world, I won't get another set till the end of the next year. I want it right now. My company needs it for something. That is my position. Shikhar is company B. He is the CEO of company B. He also wants that 100 kg oranges. Again, the last batch, nothing else is left, nothing till next year. His company also needs it for something. As all of your mediators, what will you ask? The first question that you'll ask, what will it be? We have to reach a settlement here. What will it be?
What do you want it for? I mean, what's the
Yeah, who
purpose?
said this?
Manat, ma'am.
Anant. Very good. Yeah, Malika.
I think Kanchan also had something to say.
Yeah, go ahead. Everybody, I want to
Exactly.
hear multiple responses. Everybody, come on. We have
Yes.
one. Manat said, what do you want it for? Who else? Come on.
Yeah. And irrespective of it being right or wrong, you can just
Yeah.
state it.
Yeah, just say it. Yeah.
If the parties are ready to share.
Okay.
That's nice.
Okay. What else?
Ma'am, if you have a viable replacement for oranges,
Okay. Very good. Very creative options. Very good. Yeah. What else?
Ma'am, if there's
Uh,
someone, I mean, who could pay more?
All right.
Bidding.
Okay.
Nice.
Smart. What else? I'm so glad we have so many different responses. Come on, guys. क्या सिर्फ तुम्हारे बैच में लड़कियां ही हैं क्या? There is
Exactly.
no
That's-
guy.
has a relevant
No.
cause, like
Yeah.
something
What?
important. Like who needs it more?
Both of them need it equally. But good. Okay,
Okay.
another response. What else? Come on, guys.
I guess it's like the parties are trying to reach a settlement. It's like a compromise.
Yeah, so as a mediator, what question would you ask? My position is that I want that 100 kg of oranges. His is that he wants that 100 kg of oranges. And while we have some amazing questions, which yes, the mediator is definitely supposed what else? What did Malika say?
Ma'am, if the parties are willing to share it.
Yeah, and what did I think Vimuru said something, if I'm not wrong?
Ma'am, it's Kirti, ma'am. I said whoever is willing to pay more to the person.
Yeah, and then Kanchan said something. All right. I can't. Yeah. Yes, Kanchan.
No, ma'am, I didn't say anything. Actually, I was on that sharing wala note, so Malika said it.
Acha, okay. Okay. And Manat said why they wanted the oranges. So very good, very happy with all the responses. And this question that Manat has asked, the first response that we got, is what explains the idea of what an interest is. Why do you want it? That is the first question that you usually should ask. While the others are also very important, they are questions that can follow this. But why somebody wants something is what will lead you to that person's interest. So very good, Manat. What you want is your position. Why you want it is your interest. I want the orange because my company, this is in my confidential information. So now I'm just telling you guys like that. My company has developed a cure for cancer and we need the orange peels. Shikhar, in his confidential, knows that his company has developed a cure for some other very severe disease and they need the seeds. So this is where our reasons are why we need the oranges. That is different. So we don't need to share. We can all get 100 kgs worth of quantity and we can still divide. And how did we get to this? Because we asked why. We found out the purpose of why they wanted the oranges. You keep asking why, multiple whys, why. Right? Is
So
that
ma'am,
clear?
the question of why, I mean, if we are the mediator and if you're asking the party why do they need the oranges, now this information would be in their confidential information which they're not allowed to divulge as a normally, right?
No, that's not the case. They
So
can
how-
divulge it if they want to.
Okay, so wait, they can divulge their confidential
They
information?
They
Okay.
can do it.
Ma'am, I
So
think you're
now-
cracking up in between. You're just lagging.
Sorry?
Ma'am, you're cracking up in between your voices.
Is it better now?
Yes, ma'am.
Yeah, so there is no hard and fast rule about parties not being able to share their confidential information as such. Now it is up to you. You have to take that call. If it is evidently detrimental to you or your company or whatever you're representing, then of course you wouldn't want to divulge it. For example, if it's given in your what do you say, in your confidential information that your company is going bankrupt, you don't want the other party to know that, because that is detrimental to you. It will get you horrible deals. So that is something that you don't divulge. But telling the other party here that you have developed a cure for cancer, it's very important, blah blah blah, this is nothing. It's fine. It's okay if they know. You're not giving them the formula, right?
Right.
Never agree to give them the formula. You can't tell them the process. You can't tell them the cure. Don't tell them anything about the cure. But you can tell them that your company has developed a cure, right?
So we share the information only when it's imperative, or we can share it like normally also.
You can see sometimes the confidential information is so obvious. Yeah.
No. For example, in this particular case, we have the cure for cancer, which is a pretty big deal, right? So if they're hell bent and not agreeing to a settlement, and if they're not willing to, share, or whatever the other options are, so we have to let them in on the information and tell them ki bahut zyada important hai, so we need it, right? But for example, in other cases where something is not so much important as for example, the cure of cancer. So do we have to share our information? Like, is it the part of a format to share our information, or it is upon our discretion that we can or we won't?
It's up to you. It's up to you.
We don't get marked down for it.
I just pitch in?
Yeah, of course. Just one thing. So if you have to be smart about it. If you can see that the other party is not willing to share if they're very hell bent on hiding from you why they want the oranges, then that will mark the they aren't willing to reach a an agreement, right? However, divulging this particular information about why they need the oranges, it's okay. But your point about how important it is that they found a cure for cancer, and that definitely outweighs whatever the other party's reason is. You can't say that, because this is a business deal. You can't say what is morally. You can't say कि हाँ बंदे मर रहे हैं, हमको चाहिए. You can't do that. So that the point about
Ma'am, are you there? All right, till the time Aishwarya ma'am is back, I'll just tell you, Manat, what's the case with confidential information is. So CI is a very toss-up game. Whenever we have been given CI, it's all about the scope and mindset with which it is being built. I'll tell you, it is very much situation specific. At times, I have gotten a CI in which I was given the same CI, the other party was given the same CI, yet there was a proviso in which we were stated that if the other party asks you this question, that why and how something is happening, then we have to answer that. Even it might lead us to detrimental of our case. So Aishwarya ma'am, since you're back, I just adding on to things.
Continue, Shikhar.
All right. So at times it has happened that I have been given the information that I have to divulge it if they ask me why. But it has been devised in such a smart way that the other party, if they have to ask me why, then they also have to tell me something else in return. So these drafters of the CI are so smart that they have been given in such a, or these have been drafted in such a way that neither of the party is losing anything. Yet, if you haven't divulged any CI, since you have given under CI, you have been given 6 points, and you haven't talked about or touched upon each of the points, and you have left out the last point, which was very much crucial, which could have taken your discussion for 20 minutes more, and you haven't done that just to be on the safe side, then also it's a minus point for you. And if you have given it too much before the other party as well as the mediator, then again judge is having the CI from both the sides, and he can see that this party is on a very dumb note, he has revealed that information which he wasn't supposed to do so. Then as per that, we'll be marked down. So, yeah.
Right, sir.
So it's very situation specific.
Yeah, and you also have to make sure that you're not wasting too much time emphasizing on the same point again and again. You try once, you try twice, but if you see that the other party is not willing to compromise on that particular thing, you don't stay there. That is something that wastes time. If you feel like at this
Exactly.
stage, because this is something that parties do a lot, they will spend 40 minutes of the entire 40 minutes trying to force the other party to agree to their solution. अगर किसी को शेयर नहीं करना है तो नहीं करना है, as simple as that. Again, you try, you give it a shot, you try once, you try twice, but that is it. Don't waste time. You tell them that let's move ahead, let's move on, because our aim is to reach a mutually agreeable solution. And at this stage, if you feel like divulging your CI will help you, then just divulge it. All right.
And if you're doing it again and again, just like Aishwarya ma'am said, then it is a situation in which judge will see through. First of all, you have to see through that this is something that they can't divulge, because you're also as good as them, and you can't also reveal it, and they also can't reveal it. So if there is such a situation in which they can't do so, then the judge will see that this is a position in which the other party is leading the situation to a discord, total discord, and it's a very loggerhead situation. So it's like a lock from which you can't get released, both of you. So it ultimately it hasn't resulted anything substantial. So you just have to leave it and move on to the next issue. Also, you have many.
I'm so sorry to cut you off, Shikhar, but this is the ideal point for me to mention that in a situation like this where you've reached an impasse, that is a place where you can't, where it's a roadblock and you're just stuck moving in circles, you just can't get out of it. This is the right time to call for a caucus, right? When you feel that you're stuck, you're talking about the same thing again and again, it's wasting your time. You just call for a caucus, say that you want to have a private discussion with the mediator. This is the ideal time. And this is where, if you feel like divulging your CI directly to the party can be detrimental, then call for a caucus, divulge it to the mediator. At least the judges know that you have divulged it and you tried your best, right? So this is another important thing. Yeah. Shikhar, I think you can come to that second example of yours, the interest in position thing.
Yeah. So when we come on to the negotiator's point of view, you also have to recognize and acknowledge the other party's interest, position, and issues. At the same time, before doing so, we have to openly tell them that this is my position. First of all, the whole picture of this trilogy comes from the position. So I'll just give you an example that I am having a dispute with my mother. I want to be back at home by 2 o'clock in the night. Okay. And my mother says that no, you have to be inside in the house by 10. Now there's a tussle between us and we can't resolve the issue. But having to know my interest is that I don't want to miss out on the social life of my place. I don't want to miss out on the friend circle because they are also having the same time as much as me, and I just want to be with them. Therefore, I just want to come back by 2. Whereas my mother is asking or concerned about my welfare, my good health, my being away from the crime or anything which takes place in the night. So these are our interests. Now comes the issue. So once we have recognized our position is something we have already, we can very literally see it, very vividly see it throughout to the GI, that this is the position of me and this is the position, will be the position of the other party. But we have to see through what are the interests of it. So this is something which I'm going to state in the next process of next 10 minutes. 2 minutes, I should say. That we have to subtextually we have to also gauge through the inherent issues or interest of the other party. So once I have said that my position is this and the other party's position is that, the interests are something which I can also gauge through practicing the sessions, and with that sometimes CI also tells us that these are the interests of it. That's why they can't lose out on this. But still, before we are coming on to the discussion part, there's a term called as information gathering. And this is all about this only, where we are trying to ask the other party, when I said in my opening statement that you have to ask the other party about their issues which they have. As per them, once they have told you the issues, when we come on to the discussion stage, now we ask them why and who. So this is a very thumb of rule thing in which you have to take the session from the starting till the end on the basis of a why and who phrase. You have to ask the other party. Don't jump onto the conclusion by giving them solutions. First of all, ask them why is it the case. So had my mother not asked me why do I want to come back at 2, would I be able to solve the situation? No. So therefore, we have to ask them that what's the issue and why is it happening. As per that, they will tell you the interest of theirs. Now we'll come on to the issues and issues are something very much coming from the point of view of interest only. So issues are something agendas which the mediator will form at the end. As per that, once you have resolved
in the beginning, the mediator will form in the beginning, not
in
the
the
end.
beginning. Yeah, sorry. So once you have told the other party as well as delineated your own issues and interest, then will come the interest and the position. Then it's all the work of the issues/agendas. As per that, the discussion goes on. So before discussing, just make sure that you are going into this whole tunnel of information gathering. As per that, once the whole situation is crystal clear before you, then nothing is convoluted before you. You can very easily go through it. Yes, ma'am.
Shikhar, we have a raised hand here. Ranjul Malik.
Yeah, Ranjul. Ranjul, are you there?
I think he did it by mistake.
Okay.
Okay, never mind. Yeah, so
Ma'am, excuse me.
yeah.
Ma'am, can you give us some example from like a real competition that you have taken part in, about like giving a prop and giving some examples of CI and GI?
Okay. See, we will have an advanced session very soon as well, where we'll also give you a demo. But for a small example, I can tell you right now. So in my last competition, we had this prop where, yeah, Ranjul, write it down, whatever your doubt is. So yeah, an example so this was based on the conservation of wildlife and how an MNC was trying to take that area for cultivation and agriculture and everything. So while wildlife was important, it was also important for the country to generate more income. So this is the basic dispute: MNC versus wildlife. All right. Now in my CI, I was representing the MNC, and we were told that it is very important. So the issue was that the fencing around our fields was electronic fencing, and it was causing harm because of the frequency to the animals. So they were hell bent on us removing the fencing, and we couldn't do that because they were very, very expensive. All right. So this is the basic. Now in our CI, we were told that this particular portion about the fences being very expensive was given to us in our CI. So they were told that you can spend some extra expenditure on fixing the issue, but you can't remove the fence. They were told that the frequency in the fence is very, very harmful and it's killing the animals. Now, what do we do? Guys, if you have creative suggestions here, please tell me. Otherwise, I'll tell you what we did.
Maybe reduce the frequency of the
all right. Yes, that is a good option, but they said no to that because any kind of frequency was harming them. But yes, this is the kind of suggestion that you're supposed to give. All right. Yeah.
Ma'am, installing some sort of jammers.
Anybody, yeah.
Oh, ma'am, we can move the animals somewhere else if that's possible.
You can't really move the animals. You can't move all wildlife, right? That's not really. And the whole point is coexisting. So yeah. But okay. Yeah. Mannat, go ahead.
Sorry. Can we put some sort of jammers there for jamming the frequency? Like the military uses one for jamming the
Yes.
phone signals. You can use that.
Very, very good point. Another point that this is a very good point, but the reason that we couldn't suggest something like this was because this was actually very interesting mediation where there were 3 parties instead of 2. And the third party was the people who were living in that area, and their livelihood was also in question. So considering everything, we came up with an option which would help the animals, which wouldn't force the MNC to remove the fences, and which would also provide help the people living there, the rural population, with their livelihood. So we suggested that we can put an external layer of fencing, bamboo fences and all. And yes, that was combined with stuff like reducing the frequency and everything. But besides the frequency, there was also the animals running into the fences, harming their horns and everything and stuff like that. So this is what we had come up with. So bamboo fencing would help the rural population because it was their forest area. They would do the building and everything. They would be paid for it. We wouldn't have had to remove the fences. And it was basically fulfilling all purposes. So this is an example of what happens in a real mediation and the kind of suggestions that you're supposed to give. I'm happy with the kind of options that you guys generated. This is exactly what happens there.
Ma'am?
Does that help, Aditya? Yes.
Yes, ma'am. Ma'am, but what if the party, the people, rural party, if they say that this bamboo fencing is a very temporary idea, it can get destroyed by rains and like stuff like that, and even like sometimes animals come and they might destroy, like groups of elephants might come and they might destroy the fencing, and they themselves might even harm themselves by coming in contact with the high frequency fencing. So if they come up with a point like this, what do we do then?
Then for a while you try to stick to your point, because bamboo is one of this, if you even search online, bamboo is one of the strongest building materials. It can't just get damaged. It has survived rains, harsh weather, everything. So you prove your point with whatever facts you have.
Okay, ma'am. Okay, ma'am.
Otherwise, you see, it's all about you've got a valid point, of course. So then you ask them what kind of solutions they have. If they have nothing, then your solution has to stand, right? So just yeah, they can't always keep rebutting. They can't always keep saying no, तुम्हारा गंदा solution, ये नहीं कर सकते, ये नहीं कर सकते. What is their solution then? You have to ask them. Yeah. Yes, Mannat.
Ma'am, I doubt hypothetically, if, for example, in your constitution you were given that you guys are not take down fences, also you can spare some money for for trying to prevent the rays from going out.
Yeah.
Whatever it was. So sorry, I'm sick. But so hypothetically, if you were not given this clause in your confidential information, for example, it had just said that you're not supposed to, and then you have to
that you're not what? I'm sorry, you're cracking up. For example, it said that you're not.
That you're not allowed to take down the fence, the main clause, and this clause of extra money for making other arrangements for the same, not given. So it's like you're not supposed to take down the fence, you're not supposed to spend money on it either. But would you have come up with them?
I really can't hear you. I'm so Shikhar, could you hear that?
No, actually, Mannat, what you can do is you can just put down
type
the
it. But if your question, I could hear it in parts. I couldn't understand the whole thing. But if you suggested, yeah.
Are you able to hear?
Yeah, it's better, but yeah.
I'll just quickly say, if you were given in the confidential information the clause that you can spend an extra money for making arrangements for the damages caused by the fence, right? So what if you were not given that clause? Your main objective was to not take down the fence and nothing else was given. What would you have come up with then? What solution?
What solution? Yes, if they hadn't told us that we're allowed to spend extra money.
Yes, ma'am.
Then I would have asked for money from the government, because it was the government that was complaining and the rural people.
Right, ma'am. But why would the rural people pay money for this?
Not the rural people, I mean the government. So it was a really confusing thing where the government was it was something like a village panchayat.
Right, ma'am.
So it was also representing the people's needs, but it was also the government, and the government always has money.
So we just ask them to collect the money and then make the fence for themselves, so that
No,
they
we'd simply ask them to pay for our fences, which would also help us build a better fencing or a different material ki fencing.
and employ the rural area people so that they
Yeah,
get the money.
exactly.
Right.
Yeah.
So we can have these kind of examples sort of thing, because when I went for this competition I had this Messi and Barca fiasco thing. So it's super interesting. So we can have the session afterwards also. But
Yeah.
and if people are interested, then definitely we can discuss such kind of scenarios. Before that, like before completing this session, we had just one or two pointers left. That was Batna and Vatna. So, ma'am, I'll just
Yeah,
summarize this.
quickly, because we've
Yeah.
already, yeah.
Hmm. So, Batna is something which, first of all, I'll just tell you the definition of it. It's called as best alternative to a negotiable agreement, and Vatna is the opposite of it. That is worst alternative to a negotiable agreement. And you might be thinking that if it's called for an alternative, then it is something which you have to give right there. But it is something which is different from your whole negotiation which is happening right now. So it's not something that one idea didn't work, then the other idea which you're putting forth before them, then that's your partner. And if the worst case scenario comes, then you're putting forth another idea, that's the partner. Basically, Vatna is from what I have seen is about litigation or something out of this whole discussion sort of thing.
Yeah.
And when you go outside this mediation thing, and then you give them solutions. So I'll just tell you, Messi and Barca fiasco, which was happening. Messi had left the club for a while because he had some issues with the club, and now the two sides, the club and the party and the Messi, they had come on the table and to discuss this whole issue. Ultimately, if this after this whole discussion, this argument or this discussion didn't work out, then for club the partner would be that they go to the court and sue Messi. As per that, they gain their whatever the indemnification they want from Messi. This would be their partner. Vatna will be they again go to the court, opt for litigation, destroy their whole reputation, both of them, and then they get nothing. This is their Vatna. So it is just situation specific thing which I told you. We can have many more examples of this sort, but I just want to give you an idea that Vatna and Vatna is something which you also have to know. There's something called the mind play, which even the judge will ask you. It is based on the competition to competition thing. Yes, ma'am.
Yeah, it depends on what competition you've gone for. So in a lot of places, they don't separately ask you what your Batna is, what your Batna is. It's just something that you should know. You should be aware about it. If you're able to make a reference to it during the session, for example, if I say in the very beginning that you see that our client has already suffered a lot of damage to his reputation, and your client, not your client has already suffered a lot of reputation to their damage, and if we go to court, he'll suffer even more damage. So for you, we understand that the best that litigation is the worst alternative. So you can just make a random reference to it, which will come to which the judges will notice, and they'll be aware of the fact that you know what Vatna is, you know what Batna is. So you can be smart about it, but it's not like in Shikhar's competition. They after the session was over, they separately asked them what their Batna was, what their Vatna was. In our competition, this was a marking criteria, understanding Batna and Vatna, but we weren't ever separately asked. So it depends. It's just something that you should know. Just the concept should be clear. So, and this is also something that takes time to understand. Just read about it. Read a couple of. Take a look at some of the mediation sessions that are available on YouTube. You'll find some good ones. So yes, watching videos on YouTube really helps. If you're serious about mediation, do give it a try and watch some videos. It's very interesting. It's very fun. It builds your skills that way. It's very good. So I would definitely recommend that you try. Yeah.
So on that, we can just sum up this session with the closing statement. So, closing statement from the negotiator's point of view will be when they have, come up to a solution, and the councils are discussing that whatever, if need be, then we can have subsequent sessions. Otherwise, if need be, we can have a non-disclosure agreement and we can sign it over here. With that, we can, jot down the points of this, whatever we have.
Or you can just say that we'll get the agreement formally drafted by the councils, and we will meet up for the signing of the contract. And then you just say that it was. Then it's just all thank you for taking our time. We're glad that we're able to reach an amicable agreement and stuff like that. And usually you don't get this much time because by this point your time is up. So it's all quick thank you, and that is it.
Right. Always goes in this manner.
Yeah.
So my just parting words to you all would be that throughout the session, just try to be as humble as you can, and just try to go for cooperation mindset, with a cooperation mindset that you are.
Don't be arrogant. Yeah.
Yes. And whenever some tussle sort of situation comes, then you have to acknowledge that also. You can state that since right now we are not in a mood to, or the party's emotions are running high, we can have another sessions as well, so that just to sort out things and we can know each other very well.
Running high mat kehna, lekin something similar you can say. I mean, you can you can just say that since we've since the discussion has become a little agitated, we can take a quick 10-second break, breathe, and then begin again. So just say something like that. Or you can always suggest that since we've already talked about this issue for some time and we don't seem to be reaching a conclusion, we can get back to it. And in the meantime, we can talk about the second issue in the agenda. So this is something that is also done. It can be suggested by the mediator as well as the parties. So yeah. Guys, the floor is open for questions. Go ahead if you have any. Otherwise, we'll quickly wrap it up because we've already overshot. Yeah. Shikhar, do you have anything to say?
No, I can rant on, talk about this whole mediation thing because I'm just messing up with the whole concept. So I can just state you that it's all about dialogue thing, and never go for the monologue thing that you are just speaking and the other side is not getting a chance.
Yeah, make it look like you're actually having a conversation.
Right, exactly. And it's much more fun than mooting. So,
wait,
I don't know, am I allowed to say that?
We're not, this is being recorded.
Because being an MCS member, but at the same time, we are also the ones who, okay, I won't reveal anything else, yeah.
Every competition is fun. But yes, mediation is extra fun. That's what we can say. All right. Nobody is really responding here. I'm sure half of you are asleep. But this was fun. I really hope that this was helpful.
Okay, I can't understand. Yeah.
Yes,
ma'am, excuse me, ma'am.
Ma'am, the job of a mediator is to convince the parties or to convince the judge?
The judges are nothing. They are just assessors. They will only be witnesses. They have nothing to do with the session besides marking you. Convince the mediator kahin karna hota hai? What convince? They just have to help the parties reach an agreement. That is it.
Okay, ma'am.
You ignore the presence of the judges. If it's a virtual competition, the judges are asked to mute their mic and turn off their cameras. So they're not even there.
Okay, quickly. Akash, can you...
Sir,
yes, Malika.
So I was just saying that Malika has a question. I just saw a raise of hand from her side.
Before that, do you want to switch off the recording right now? Or do we want to record
I think it's over, so you can just...
I think we can even keep a questionnaire session for the recording, right? So that if people who are viewing the session, if they have the doubts and these come under the questionnaire sessions, so that would be more clear for them.
Okay.
All right, Malika, go ahead.
Ma'am, so it's just a very basic question. I just want to ask that, ideally, how many issues are given, and what is for a mediator, how it is how many issues are resolved if in that one session are supposed to be good, that we'll be marked well if we were able to cover this many issues.
It's not fixed. It doesn't matter, to be honest. This is not like a moot where you're given the number of issues. It's just something that depends on what the mediator gathers from the opening statements of the parties. It doesn't matter. It won't mark you down. Some people have 4 issues, some have 5, some have 3. If you're there physically, you usually write them on a board. There's a whiteboard there. You just write 1, 2, 3, that this is what we're supposed to discuss. There is no fixed number. Even if you're on the first issue and the time gets over and you're not able to come to a conclusion, any sort of progress that you make, just summarize it at the end so that it looks like you have made progress. Even if it's not you reaching a conclusion or a proper agreement, there is some progress. You just have to show that. So again, even if you've not, it doesn't mean that you have to complete discussing 2 issues or 3 issues. Aisa kuch nahi hai. It does not matter. What matters is the way you go about the session.
So, ma'am, we basically have to ensure that, till the time the session ends, both the parties are not at least at an impasse. We've made some progress from when we started.
And you as a mediator are able to understand the interests of both the parties. You're able to understand what they want, why they want it. And same goes for the parties.
And adding on to it, what ma'am said. So Malika, it's not always about giving the suggestion or the solution. It's more about understanding the cause of it.
Yeah.
So once you have done that and you have expressed it throughout the session, then you have won the game.
Always remember that if you're a better listener, you will be given marks for that. The judges always notice that.
Right. And even if your solution didn't work, you have asked the other party to throw the solutions on the session, then definitely you are you have taken that upper hand and you have won the game.
Ma'am, I had it out again. Sorry.
No, go ahead.
It's just a doubt in the format. In the end of the session, do the negotiators and the clients, do they also summarize it or just a mediator?
No, the mediator usually does it. The negotiators usually confirm or they suggest or they make changes. So for example, if the mediator says something which isn't exactly what the parties had agreed upon, then the parties can always say that I would just like to correct something here or make a correction. This is what we had decided upon, not this. This is what they can do, but usually the mediator is supposed to summarize. Sorry?
They don't have a separate speech, right?
No. No speeches towards the end. It just ends with a thank you.
Got it.
Because all the more because you don't have so much of time to.
Yeah, you don't have time left. So yeah. All right. Any more doubts? Yes.
Being a party or being a client, do we have to like play hard to get or hard to understand, or do we have to be adamant on our point that the mediator is not able to make any progress? So do clients get marked up for that? They are an adamant party and they are true to their point and they are not willing to change, or like do we have to be amicable and do we have to like agree to what they're saying?
Both. So mediation is about fulfilling your interest while being amicable. So you basically have to be 100% adamant on getting your interest, but 0% adamant on your position. Okay?
Okay, ma'am.
So this is, you can't give up your interest. You have to emphasize again and again on how important it is. Like in that example, the orange example that I had given you, neither party could give up the oranges, right? Both of them, none of them could, because unka reason wo tha. So they could give up the whole, as such, they could give up, for example, one party could give up seeds and everything, but they wanted the peel. They'll get the peel, the other party will get the seeds. So this is, you understand how they are getting their interests, but they also compromised. This is what you have to do.
Yeah, okay, ma'am.
Ma'am, one more question. Ma'am, are the parties, let's marked on the basis of how amicable that solution is? If I, in the orange example only, if I give this suggestion that, okay, we'll just take the peels, we'll give you the seeds. but the other party refuses to it. So would the parties be marked on the basis that, how willing they are to accommodate each other, or, how understanding they are towards the needs of people?
Definitely. If they refuse to accept your solution without any valid reason, that will definitely mark them down.
Right. Even when the other party has said no to any of your solution, ask them why and how.
Ask them, yeah. Ask them the reason why they're refusing. You have to see, this is all of this is a part of understanding their interests. Why? Keep asking them why.
And as per that, shift your solution, or mold your solution so that you are being more smarter by each inch you're moving to the ending of this whole discussion.
Yeah.